Okay, I want to look at administrative law. And I've set this up to see on my second statute, so there's going to be a little odd interplay. I'll be jerking back and forth. But um, administrative agencies are set up by a statute. So I'm talking about after the statute, after setting this up, how do we interact with the agencies? And that's primarily what we're going to be talking about here. Um, I kind of throw that there will come a knock at the door. The agency that you're dealing with, and as we step through this, we'll see that sometimes the agency helped create your business or licensed your business. Um, but as you're dealing with one of the things you want to look at is how do I reduce or eliminate expenses relative to administrative agencies that may oversee my business? Um, I think key elements here, how do you interact with the agents and the agencies? I'm obviously at home. My wife's doing something with an egg, I think, there. And you should set goals and create plans. How do I comply with the agency without deeply hurting my business? So, we've got sources and bounds, if you will, of regulatory authority. As we're looking at the agency itself, in the federal Constitution, there are limits placed on agencies. Primarily, what the textbook talks about is kind of search and seizure, the Fourth through Sixth Amendments, due process, those sorts of things. I think it's worth noting that in a lot of the state regulatory environments, the administrative agencies were set up as creatures of the state constitution and oftentimes are overseen directly by the governor. They're kind of adjuncts of the executive um, function of the governor's office of each state. And we get some parallel with that in the federal system because most of these agencies really are subject to the administration that is currently in office. And we can see, vastly different regulatory schemes in play just in between the Obama and the Trump administrations. Same thing going back to Bush. Clinton, probably now dating myself, I've lived through all of them, all the way back to I guess Kennedy was, well, actually Eisenhower was president when I was a kid, but I don't remember him as president. All right, so that mentions the state-created agencies. Search and seizure agencies have limited ability to just walk into your property and start grabbing stuff. They may need a warrant. At this, telling them you need a warrant may or may not be the best way to deal with an agent who has a reasonable right to inquire on a specific topic. I urge cooperation with some sense, and if you go insisting, oh, go get a warrant, they may come back with a whole bunch of agents if they think something big is going on. So there's something in the Administrative Procedure Act um, uh, where you're entitled to due process. Due process really just means notice and a hearing. It doesn't necessarily guarantee you a positive outcome. You do have the right to judicial review of most agency actions, but as we'll see, there are some agencies that are essentially a closed shop. All of the review of agency action is done by agency insiders, and there's no right of judicial review. There's some real questions about whether those are constitutional, but we're going to kind of leave that going away. For the most part, you may want to look at the enabling statutes. An example I give is OSHA, Occupational Safety and Health Administration, which was really charged originally with prevention of workplace injuries. I might say it's more minimalization of workplace injuries. Uh, but OSHA is a good example of a pretty well functioning agency that tries to balance all the competing interests of employer, employee, public, local governments, all that kind of stuff. I think they do a pretty good job. As we're looking at things, so agencies are oftentimes given pretty broad latitude in the enabling statutes. Some people say that Congress has just kind of kicked the ball over to a bureaucracy. Um, there's good and bad in bureaucracy. You get some people who are relatively expert in that particular field and know how to drill down, know how to communicate in that field, have expertise in that field, whereas Congress or state legislatures tend to be jacks of all trade, if you will, much better at getting reelected than maybe getting real work done. And so let's look at how do they make the rules under which the businesses that operate within their jurisdiction must operate. And it generally begins with the agency studying or researching the direct edict that created them or the additional burden given to them by the new statute. Um, there may be some shifting. There's always some agency shifting, and all of a sudden, an agency that didn't have oversight may add that into their oversight because they've been melded together. This happens periodically, then they're broken back apart and reconstituted. A lot of, like, I think HUD, Housing and Urban Development, no longer exists. It was a big deal in the 70s and 80s. So these things come and go a little bit, but basically they're going to do study and research. What that means is they may talk to businesses, talk to interested parties, gather data, look for university studies, hire experts to help them formulate regulations, look at existing regulations. Can we modify these? Is this what we're proposing? That gets you into a slightly different status when you're trying to modify or amend an existing rule. You know, the strictures are similar but not the same. So once they come up with a rule they think they want to publish, they have to publish it. Then they invite comment. Okay. And ordinarily there's a 60 to 90-day period permitted for comment. A lot of times businesses will submit written comment because they were part of the original drafting product or process. Maybe they know where they want to push back in advance and they've already written things out and they've done separate research. That can have pretty good weight. Testimony, oral stuff just generally isn't quite as powerful as written, because written we can study, it sits there, we can respond to it. And so agents and the managers of agencies tend to like written responses better. They may have testimony. I recorded this once and it failed. There's I had sent it to the wrong flash drive and it blew up. So I'm re-recording this, and I'm not sure I'm doing any better than I did first time. But let's just say that there's rulemaking about how to build a pipeline. As we're doing this, we may have testimony taken in various places where we know a pipeline is going to be proposed. The Bakken Shale in North Dakota, we know at some point they've got to get that oil to market. And so they're going to propose something. We may have regulations sitting there. We may, in advance of proposing the rule relative to it, have gone in and had hearings in advance. But as we publish it, we may go into these territories and ask for public feedback, permit testimony, decide which witnesses we're going to have. There is some legislation that attempts to protect small business. There's some real barriers to entry, if you will, in regulating businesses. Small businesses don't have the sophisticated voice that a big business does. And sometimes, and I see this repeatedly in the Wall Street Journal, there are entities that want the government to regulate their business more because it actually, they can sort of drive out free-based competition, because you have to comply with all these regulations before you can even get in and get started. And that's a big barrier to entry. So there's some, at least lip service given in statutes, that as we create these regulations, we have to look at what's the impact on small businesses. And they're going to have to do a kind of checkbox. Did we impact this? Did we study how this would work? Small business tends to be identified as firms of 500 or less employees, which is still pretty big business to me. But anyway, ultimately, they're going to go through maybe a period of revision. They may say, no, we're really happy with what we've got. And then they'll go out to final publication. Before implementation, there's a period of time where you've got a right to go get judicial review. You know, as we're going to see, in most cases, judicial challenges go nowhere because there's sort of a deference to the agency. The agency had to act in an arbitrary and capricious manner in promulgating these statutes in order for us to get them shifted. So once we've got the rule in place, and for a lot of them, they're already sitting there, the Code of Federal Regulations, the CFR, which follows this statutory scheme. There are 1 through 50 titles in the U.S. Code. The same title number is given to the regulatory body created under that. I think the Internal Revenue Service is 28 and OSHA is 26, or it's vice versa. Those are the two I dealt with the most in my practice. Anyway, I've got probably an inflammatory statement in my enforcement file, but notice we've got, this is really fabulous slide work. Enforcement is a red. You know, we may shut you down. Licensing, green, you've got the right to operate under our licensing sets. And then inspection, you know, here's the yellow light. We may hold things up while we come in and look and make sure you're still in compliance according to licensing, still in compliance through enforcement. Periodically, and this happens to me, at least I've seen it more, at the local level, you'll see a kind of regulatory shakedown occur. Businesses are oftentimes looked at on as cash cows that will gladly pay fines and penalties in order to keep going. So all you have to do is walk in with one regulatory body and find a few things wrong, and then because of those, you send in a different regulatory body, and then they find some, and they find some, and blah, 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 blah. And pretty soon you've got all 15 regulatory agencies in there going, you know, we're finding a lot of problems here. And so they force a settlement. And I saw some big settlements during a certain administration, $400 million to get rid of all regulatory agencies. So, you know, it may or may not be happening. You know, there's a monitoring agents may find something, then they may bring in subspecialty agencies. I don't know that this really occurs. It sure looked like it, though. You know, in the monitoring process, I think it's important to keep in mind that generally the agent or the agents or the agency itself is interested in keeping active businesses going. You know, if they're in constant violation and they're always struggling with them, you know, shutting this place down is a last resort. You know, this could be a small town in Nebraska that this is one of the major sources of employment. You know, we're going to be careful before we shut that down. A friend of mine used to I think he was a food inspector, and so he went to a lot of slaughterhouses. And he tells me, there were some good ones and there were some bad ones, and you knew walking in what you were going to get. And so what you tried to do was keep them operating, but get them to a better state. And you had to show some patience with some of them. Others hopped to it right away. Um, you know, I think you, as you run a business, have to make this a decision. What am I going to do? What's the right thing? Anyway, they've got a right as a regulatory agency. If you look at a slaughterhouse, the Food and Drug Administration probably has jurisdiction over that slaughterhouse, and they ordinarily schedule these inspections on a regular basis. A lot of times they're going to know you're coming, and the deal is we gave you 2 days notice and the place still looked like this. Come on, what's going on here, guys? Do I have to bring the team in? So as they're inspecting, they may say, look, I found 40 different violations. Here are 28 of them that I think deserve immediate attention. Here are 10 that are pretty serious. We've got to do something about this. What's a good time for me to come back and we're going to look at this again? And, if on return we come back and they've got, 26 of the 28 dealt with, and the other two they're working on, they've got some issues, they had to go to outside contractors, blah, blah, blah. Of the 10, they've only done 2 of the big ones, but they were really big. And the other 8, they've started the ball rolling. All right, maybe I'm going to back off the enforcement here and kind of give them a little space and say, all right, I'm going to come back in a couple of months. Let's see where we are then. They've always got a right to kind of inspect the premises in a reasonable fashion. They don't necessarily have to go into private spaces or into office spaces. There's a little bit of barrier there that we can maybe get some enforcement against. What we've seen in the statutes a lot of times is that the empowering statute has sort of created a record-keeping duty, if you will. You've got to have regular records available for inspection. That's where you oftentimes see 2 sets of books, the ones for the agent and the ones that are real. I hope you're not into that kind of thing. They should be the same for both. That's a much better way. If they discover that second set, your goose may be cooked. And as we're going to see, there's a lot of criminal penalties associated with some violations. You just don't want to go there. I think the environmental law one may talk a little more about that. You may actually have to produce documents. Where's your paper trail? I know in the environmental, you've got to have a real paper trail on where did this come from? How are you going to get rid of it? How are you going to contain it after its useful life? How are you going to tell the public how to contain it? All of that may have to be documented in apple pie good order all the time. If your documents are not well maintained, that's an indicator that there's a lot more wrong, and we may do a deeper look. We may go look in the corners and the crooks and channels. You don't want to get them to that space. You want to keep them in this cooperative but somewhat adversarial field. They're not necessarily your best buddies, but they're not really looking to shut you down either. Some statutes require statements of owners and executives. I remember the Sarbanes-Oxley Act for a while had some really big teeth in the top 5 people in CEOs of public CEO spaces of publicly traded corporations. I think those have backed down. I haven't seen it directly, but when it was first passed, they really were after executives. And, so it flowed into other owners and executives. Sometimes there's personal liability for these people. As we looked at in corporate structure, one of the reasons we create a corporation is to limit personal liability. Well, as this has been abused, slight inroads have been made here. We can make some slippery slope arguments that as we begin to encroach on corporate autonomy and get into personal liability, where does all this end? That's a little bit ahead of where we are. Um, if a ruling comes down that's adverse or that you want to challenge, ordinarily you've got to follow a pathway up in the agency. Um, and the agent, sometimes the agent overstepped and the agency recognizes it and they give both of you a break. Other times they just rubber stamp what the agent said, and it may be that that's a really good agent, and that's why. Um, Getting out to judicial review, as we're going to see, doesn't necessarily get you much because our next slide is going to reveal this for us. Um, you know, the agency and the agent had to be acting in an arbitrary and capricious fashion. Okay. Over here it says acts of agencies are deemed prima facie reasonable. That is, on their face, they're deemed to be reasonable. The burden of proof is on the person contesting the agency action. So you've got to be able to prove that this agent was, in fact, arbitrary and capricious, or that the agency itself was that. Um, so I kind of tell us good luck in court. Some agencies, but very few, are closed shops. There is no right of appeal out to a court afterwards. Um, I think we've made it fairly clear throughout this that agents and the agencies and the bureaucrats and the bureaucracies, pretty much 80% of us are decent, good, solid, honest people. But the outliers, they're in a different category. And it's not like there aren't any outliers in agencies. There are times when, these agencies really get a burr under their saddle and they go after enforcement heavily. Um, you know, you're going to see times where the system seems to be paramount to common sense. I would caution that this may be your first look reaction. A lot of times it's because we don't fully understand the why of agency rulings. If you give them a little more time, give the agent a little more time, I'm not saying having a sit down, have a coffee and a smoke with them or something like that. Get to know them a little bit. Don't make it obvious that, hey, I'm asking about your kids because I want you to go soft on me. Agents see right through that stuff. You know, they don't mind having some kind of a friendly relationship, but keep it professional too. Um, I probably should have looked up the fifth estate. I forget about which are the estates, and the fifth estate is the press, I think. But my point in putting that in there is that the agencies have now grown kind of a behemoth head of their own, if you will. When I first began teaching legal environmental business, I thought the European Union was going to be the predominant world force and the world regulating force. That fortunately has not proved to be true. There's enough infighting in Europe that they're not able to get complete accord on all their regulations. Um, but this bureaucratic state doesn't get smaller. It tends to just get bigger and bigger and bigger. Um, you've got some rights under the Freedom of Information Act to get in and look behind the curtain, if you will, at agency decisions. But a lot of agencies are really pretty good at stonewalling and holding up the process. And even with, and it's on both sides of the aisle. Democratic administrations may stonewall with this kind of agency, while Republicans stonewall with a different kind. And so it's, you've got some power here, but don't expect the courts to really be exceedingly friendly and gung ho to nail these agencies to the wall. Um, there's kind of a double back scratching. You scratch my back, I'll scratch yours. Insider's game here that I call the old person network. Um, you know, the agents are presumed to be reasonable, and that's a fair assumption. There are times when they're not. Certainly, there are times when I read the Wall Street Journal where it seems like they're absolutely not. But as my wife reminds me, that paper has some tendencies to be partisan in favor of the businesses are all good. You know, when I was a kid, the businesses polluted a lot. It wasn't necessarily so cool. So, you know, let's close this with a reference to the states. The states tend to mirror federal system, um, but a lot of times they have a broader reach. They go into more narrow categories. They are constitutionally enabled, so some of them have longer lifespans than some of the federal agencies. You know, the growth of bureaucracy at the federal system is a fairly new occurrence, and we can see why our founders weren't real keen on it, because you know, once they sort of take on a life of their own. Not that that's necessarily bad, but um, you know, there's always this sort of legacy of, hey, that's always been our turf. You know, you're going to see a lot of turf wars out there in the agency deal. You know, my general advice is you're going to be regulated. Accept that fact. Accept that the regulator is just doing their job. They're trying to do the best they can. Sometimes the regulations are a little confusing to them. You don't want to get them with their hackles up. Um, you know, you want to be cooperative, um, but you know, don't just give it all away. You know, get to know what these administrative rules are in your field, and try to get comfortable with them and try to implement them as well as you can throughout your career. Thanks for listening.